2B of the same provides as follows, and I'll quote, every accused person has the right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer it. Also relevant to this matter is Section 134 of the Criminal Procedure Code, which provides as follows, and I'll quote, every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or the offense which the accused person is charged with, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged. End of quote. The argument between the parties hearing is that while the prosecution holds the view that the charge sheet is valid and has conformed to the requirements of Section 134 of the Criminal Procedure Code, since the offense is known in law, the suspect hearing is of a different persuasion that the said charge sheet was defective, since an email address was specifically set up to Parliament for receiving views from the public in the full realization of the national values and principles of good governance in form of public participation as provided for under Article 10(2)(a) of the Constitution, which states, and I'll quote, the national values and principles of governance includes A, patriotism, national unity, sharing and devolution of power, the rule of law. 118 of the Constitution provides as follows, and I'll quote, subsequent law, Parliament shall A, conduct its business in an open and its sittings and those of its committees facilitate public participation and involvement in the legislative and other business of Parliament and its committees. Therefore, and its committees. End of quote. Therefore, in determining whether the charge in the case of Sigilami versus the Republic, 2004, Kenya Law Reports, page 480 held as follows, and I'll quote, the principles of the law governing an accused should be charged with an offense known and stated in a clear and unambiguous manner, so that the accused may be able to plead to the specific charge that he or she has invested. I have carefully considered the contents of the charge sheet, and in particular, the particulars of the offense are that a program hosted at http://civic-email.netfly.app automatically generated mass emails to Finance Committee at parliament.go.ke and CNA at parliament.go.ke, which was the official systems of the Finance Committee and the Clerk of the National Assembly, thereby interfering with the normal functioning of the systems. Section 16, subsection 3 of the Computer Misuse and Cybercrimes Act provides as follows, and I quote, a person who commits an offense under subsection 1, which A, results in a significant financial loss to any person, B, threatens national security, C, causes physical injury or death to any person, or D, threatens public health or safety, is liable on conviction to a fine not exceeding 20 million shillings or to imprisonment for a term not exceeding 10 years or more. A perusal of the charge sheet, it's clear that the prosecution relied on section 16 alone. I proceed now. Section 16(1) states, if one is liable on conviction to a fine not exceeding 10, states that if one is liable on conviction to pay a fine not exceeding 10 million shillings or to imprisonment for a term not exceeding 5 years or more. Section 16.3 states that if one is convicted, is liable to a fine not exceeding 20 million shillings or to imprisonment for a term not exceeding 10 years or both. Upon perusal of the entire Section 16 of the Computer Misuse and Cyber Crimes Act, vis-a-vis the particulars of the offence, the charge sheet does not allege as provided under Section 16.3 whether the system crashed. It does not allege whether it stopped working or caused any financial loss or injury to any person. In addition, it does not allege whether plainly states that the suspect sent emails to an email address created for purposes of receiving emails. It was held in the Court of Appeal case of Sigilani versus Republic. And I will quote, the principles of the law governing charge sheet is that an accused should be charged with an offence known in law, and the offence should disclose and be stated in a clear and unambiguous manner, so that the accused may be able to plead to a specific charge that he or she can understand, and it will also enable the accused to prepare his or her defense. The upshot is that, guided by the decision of the Court of Appeal and pursuant to the doctrine of stare decisis, I reached the finding that the two counts, as presently drafted, do not disclose an offence as they are ambiguous. I have stated earlier, under Article 52B of the Constitution, provides that every accused person has the right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer it. This court is also alive to the fact that the right to a fair trial is non-derogable and is provided for under Article 25C of the Constitution. Under Section 89.5 of the Criminal Procedure Code, which states as follows, and I'll quote, where the court is of the opinion that a complaint or formal charge made or presented does not disclose an offence, the court is required to make an order refusing to admit the complaint or formal charge and shall record its reasons for the order. Therefore, this court is persuaded to such opinion. The upshot is that, in line with the said provision of statute and the reasons that I've stated above, I hereby refuse to admit the two counts before this court, and therefore I hereby proceed to discharge the suspect, that is Rose Njeri Tunguru, under Section 89.5 of the Criminal Procedure Code. Those are the orders of the court.
Yes, we shall be praying that it be available with a certificate copy of the ruling for review and further directions from our office.
The rule of the court. I also want to thank the court for making a timely decision and the rights of countries.
For this progressive ruling, when we were last here in court, we submitted a lord that there was no charge before you, and we are glad that you have upheld the law and you have allowed the citizens to engage in public participation. Thank you, my lord. That is all from us.
Pardon, Your Honor. I also wish to remind the court that when the accused person was actually detained by the police officers, our gadgets were actually also detained. We wish to also have directions for those gadgets to be released immediately. I saw there was a representative from the DCI Mustafa, and as such, I think it will be appropriate to have those particular orders issued forthwith so that we can escort our clients to the CI headquarters and further, to that effect, whatever information was actually extracted from that, we want to have a forensic report to what particular data was actually accessed on those particular devices.
Your Honor, on behalf of Dr. Hamina, because I will be obliged to speak on his behalf, I want to thank the court for giving us guidance once again and giving the public the opportunity to know that they will have a right to fair trial in the court processes. I will be associating myself with all my colleagues and we will be praying for the forensic report, an order for the forensic report to be made so that it's released immediately to us. Other than that, I'm grateful to the court and my colleagues for standing with the accused person.
So now, I just want to find out, Your Honor, we're not able to comment about any gadgets that might have been recovered.
Kuna koti zingine zinaendelea, tusinyamaze. Tusinyamaze, kwani nini ndio tunawazia?
Heshimu right ya watu wengine pia.
Watu wengine wanaendelea kuendelea na koti ila yuko mteremsho huko chini. Kuchungua sana. Kuna tupigia kelele.
Nimenyamaza, bwana fanya nini? Nimenyamaza. Andika msuri.
Usirudi huko bro.
Go. Just go.
Kodi imeisha.
Nimenyamaza.
Sasa toka nje. Very good now. Let's go.
We are ready. No, bana. Let them arrest us. No, isha. Wetu. Na haki ya sholetu. Na haki ya sholetu. Tumekataa kupiga magoti mbele ya hawa wauaji. Mbele ya utumwa tumeikataa. Tutanetu tupiganie uhuru wetu. Tuikomboe elimu yetu. Utamaduni na viwanda vyetu. Komboe utamaduni na viwanda vyetu.
I'm happy that for all the support Kenyans have shown me, and I'm happy with how the ruling with the decision that was made. And I'm very grateful to my parents and my family for being here with me, and may justice always prevail. Thank you.
Roger, 1 minute for us.